in discussing personal injury topics with myself, Jacqlyn Bryant, and my special co-host tonight, my partner, board-certified civil trial lawyer, Bryan Caulfield. Thanks for joining me, Bryan.
Thank you, Jacqlyn, for having me.
Absolutely. And so before we jump into some of our discussion for tonight, although most of our listeners should know that we are personal injury attorneys, most of what we will discuss tonight will fall into that realm and category of personal injury. But of course, we do encourage you to call in with your legal questions. And if we can't answer those, we'll try to point you in the right direction, at least let you know what area of law that it might be. And of course, you can call us after the show at the office, and maybe we can get your referral to an attorney who can assist you. But for tonight's show, I want to give you all the information on how you can call in, how you can continue watching us live, and also later on, if you want to pick up the show later, we also have a podcast. So for those details, to call in tonight, and that's the best way to get your question answered live on the air. That number is 727-441-3000. Again, the call-in number for tonight is 727-441-3000. Call on that number. It'll get you into the radio station here where we are at WTAN, and we'll answer your questions live over the air. With that being said, if you're a little shy, maybe you don't want to talk on the radio, but you do have a burning question you'd like to ask, you can tune in live on our web streams that are on Facebook and YouTube as well. Right now, we're streaming live on both platforms. So if you search the law firm name Perenich, Caulfield, Avril Noyes Injury Lawyers, you'll find us on Facebook and YouTube right now. And you can ask your questions live in the chat or comment section. We'll see those and we'll read them out live over the air and answer those questions for you to the best of our ability. And I encourage you to share our live stream. So if you look in, you pull us up, you should see like a red circle around our logo that lets you know that we are live. You can see us here in the studio, myself and Bryan Caulfield. Share that with your friends. Go ahead and get the post out. That way, if maybe you don't have a question, but maybe your family member or friend on Facebook or YouTube has a question, then they'll be able to see it and get their question answered tonight. So I'm going to go ahead and do that myself as we go throughout the show and share it with my friends on Facebook. But let's say you can't tune in for the full show tonight, but you want to pick it up later and watch it at a later date. Well, you're in luck because we do have a podcast. So all of our shows, including tonight's show, are on most of your podcast platforms. So that would include Spotify, iHeartRadio, Apple Podcasts. Just search FLALAW live on the radio, and you will find all of our shows, including tonight's show, which will be uploaded later. And I encourage you to follow us. That way you never miss a show. And in case you have that long commute and you just want to listen to a legal talk show, you'll have it available to you right there on your phone or device or whatever you use to listen to your podcast. With that being said, let's jump into the show. Thank you for joining me again, Bryan. For those that have not heard from you in a little while, could you reintroduce yourself? I told them a little bit that you're board certified trial lawyer, but maybe they haven't listened before. Let's go ahead and reintroduce yourself.
All right. Thanks for having me back again. I am Bryan Caulfield. I am a board certified civil trial lawyer. I handle personal injury, wrongful death, and medical malpractice cases. I am a proud graduate of Stetson University College of Law back in 1988.
Go Hatters.
And I have been actually working as a personal injury lawyer for coming up this September on 37 years. So there's probably quite literally almost no personal injury case that I haven't seen. You know, I was thinking of some of the kind of more interesting ones I've handled over the years, and handled a plane that crashed into a car. That was an interesting.
It seems more realistic these days, given the things that we've been seeing going on with the planes. But
then one of the things you and I were talking about earlier is kind of wild animal liability, whether or not there's be liability for a wild animal injury on your property that you don't own the wild animal. And I actually had a case like that, and I successfully litigated a case where a woman was bitten by a snake.
Oh, wow.
And the snake actually got into a commercial building because they were using a very cheap way to maintain their building. Someone who was not a contractor decided the way to fix a stuck door was to basically cut the bottom of it off a few inches. And when you combine that with the fact they weren't emptying their trash enough, they had a known kind of dangerous condition out there that was attracting all these snakes.
They were attracting the snakes.
Yeah, and so then one of the snake and had to have an entomologist, had to have all kinds of experts in the case to determine what kind of snake it was from the bite mark, and very interesting. But yeah, I mean, obviously, mostly what personal injury lawyers do is what you hear every day: car accidents, motorcycle accidents, slip and fall, trip and fall. Lord knows there's no shortage of advertising to let people know that's what
this is true.
Personal injury lawyers do. But those are the kind of cases that, as you know, we handle at our firm and have done so since 1955. So hopefully if folks have some questions, the law office is open for the next 1 hour, and we'll try to get those questions tackled for you. Or maybe, like you said earlier, which was a great suggestion, you might know a friend or family member or coworker that could probably benefit from some of the advice that we can give them on the specialized topic of personal injury. And we're here to take their calls and answer their questions for the next 1 hour.
Absolutely right. So again, that phone number is 727-441-3000. The lines are open. As you just heard from Bryan Caulfield, he has a wealth of knowledge and experience. And so between the two of us, I think you'll get some pretty good insight on any questions that you might have, especially on the topic of personal injury. So we'll go ahead and get the conversation started. But of course, as we go throughout the conversation tonight, if you have a question, even if it's not necessarily on the same topic that we're discussing at that time, feel free to give us a call and we will jump into your question at any time that it comes in. So before we dive into kind of my theme for the show, I think the last time I had you here, I was asking you questions that were like the top Google searches at the time that pertain to our practice area. So today we're going to do something somewhat similar, but it's more of a true and false style question and answer session. So I kind of have a rapid fire hot seat type questions for you today. So hopefully you're ready for that. But before we do that, Brian, I did have a question. I saw an article the other day and I wanted to get your take on it as far as what's going on here recently on the new Howard Frankland Bridge. I don't know if you had heard, but apparently there's been more car crashes since they have opened that part of the bridge. And I wanted to read that article and give you a little bit of details on what's going on and get your take on it and whether or not there's any type of liability that you see. Mainly, I guess, would be the Department of Transportation, and if there can be claims that could be made. So basically, they said since the new span of the Howard Frankland Bridge has opened in March, there's been an uptick of crashes right where the bridge begins in Tampa. The curves in the roadway there have led to questions from drivers about the design. Incidents on that side of the bridge have led to major delays. And essentially, I think they said there's been about 35 crashes since the bridge opened. Apparently, people now have to look, I guess they're saying that the curvature in the roadway is causing people to be a little bit confused as to how the road, I guess the lanes are going. What FDOT is saying is that people need to, I guess, look at the signs, slow down. There are solid white lines in that curve area. And I guess what they're seeing is people are trying to change lanes during the curve, which they believe is what's leading to a lot of the crashes. So that's basically what they're admonishing people to do, is not to change lanes and to be aware of the signage. And of course, if you do get into an accident, move your car off to the shoulder so that you don't create more delays or even subsequent accidents. Right now, apparently they said that they do expect this model or curvature of the lanes to eventually change. They're trying to do this right now to accommodate, I guess, the north side of the bridge that hasn't fully shifted over yet. Apparently, that's still, I guess, under construction. I don't go over the Howard Frankland that often, but I do know that it's not completely done. This is not the final alignment, they say. Things should straighten out. The curves won't be as they are. They'll get a bit smoother as we progress through the construction, according to one of their construction managers at FDOT. And they said that they expect this to be done within the next 3 months. In the meantime, they put some extra signs out there asking drivers to slow down and watch for construction workers. So now that this kind of uptick or increase in crashes has started to occur, what is your take on that? And do you see any liability issues there?
Well, that presents the issue of sovereign immunity.
Yes.
The bottom line is when, you have someone like the Florida Department of Transportation leading this entire project and you want to sue them for negligence, there are special laws that apply to them. They're a defendant unlike any other defendant.
Right.
You know, anytime you have a state, a city, or a political subdivision of the state of Florida, like the Florida Department of Transportation, as a defendant, then the number one defense that you're going to encounter is sovereign immunity. And sovereign immunity really does two things. Number one, it caps damages at a very, very low amount of $200,000, and hopefully they're going to be, and I think they're raising that now to hopefully over $1 million. So that's one problem you have with sovereign immunity. The second problem you have is if the decision you're complaining about is what's known as a planning level decision,
right,
then that's not actionable in the state of Florida. So
that's the problem. Right.
Sometimes you, in the case where you're complaining about a design, you might have to end up finding some of the private vendors that contracted with the Department of Transportation to provide maintenance of traffic or design. But it's a totally different animal when you're going to make a claim against a sovereign. There's a different rule that applies. And so could there be liability? Yeah, there could. But there could also be a situation where the DOT might escape liability, but the private contractors might not that are involved in that.
Yeah.
So interesting case. And I had heard about that, and I just was unfamiliar with the details of exactly what was causing it, because I drove it and it looked pretty darn good to me.
Yeah, I didn't see any major issues, but apparently, you know, right at the, because I actually, after I read the article, I went through that area and I'm like, it doesn't seem all that bad to me. But he did acknowledge that the overhead view of the cameras, I guess, it looks a lot worse, the curvature, than it does when you're actually driving through it. But for whatever reason, it is causing people to get a bit confused and they get into crashes. So yeah, I did look in that article just to see if there were any private construction companies that might have been mentioned, but it all kind of circled back to the FDOT. So that'd be interesting to see if any claims end up being brought for the 35 crashes that have occurred since March, which I think that number will probably obviously grow until they get that sorted out. But that's obviously a topic that can get complicated when it comes to sovereign immunity. So anytime there's an incident involving a government entity, it's always best to give us a call and reach out to experienced personal injury attorneys who can kind of guide you through those kinds of claims. There's so many time limitations and just statutory notice requirements that come into play with that. And so you don't want to, of course, run into those traps because you didn't, properly present the claim as you should when it comes to sovereign entities. But really, that applies to most personal injury cases. You shouldn't wait, right?
Yeah, nothing could ever happen from waiting.
Right. I agree. 100%. So now it is time for our true and false session here with our seasoned board certified trial lawyer. And I think you'll find these very informative because a lot of the questions that we have here are common questions, in my opinion, things that we get asked quite a bit, I think, from potential new clients and those that hire us. These topics come up quite a lot. And as we go through our intake process and we're reviewing cases that come through our door, a lot of these kinds of similar questions come up in the various kinds of cases. So tonight we'll be touching on some car accidents, premise liability, and also some medical malpractice questions. So if that has your interest, then definitely continue to tune in. Again, the lines are open. The number is 441-3000. If you have a question as we go through this, feel free to give us a call, and Bryan and I will certainly tackle those. So first, true and false I have for you, Bryan. Is it true or false? If you don't feel pain right after a car accident, you don't need to go see a doctor.
Well, that would definitely be false in my opinion, because, many times, as you know, Jacqlyn, we have folks that have an onset of pain after they leave the scene of the accident.
Sure. Mm-hmm.
Sometimes, it's that evening. Many times it's the next morning. Mm-hmm. And so that's not unusual at all. As a matter of fact, I've sat in some depositions just over the last few weeks, and the onset of pain for both of the clients was not immediate. Mm-hmm. Because, you have so much adrenaline, something, your body kind of goes into a little bit of shock there.
Absolutely, yeah.
And, people testified that they didn't really feel any tightness or pain in their back immediately. Mm-hmm. But by the time they got home, after their car was towed, et cetera, they started feeling. And so it's a good idea, to make sure you go. And of course, now you've got a requirement that you only have a certain amount of time to go to the doctor.
You anticipated my next question.
If you're going to get your injury paid for by that car insurance you've been paying quite a bit for,
right,
then you've got a 14-day time limit to get yourself to a doctor.
Absolutely right. And so I agree that would absolutely be a false. You should certainly get checked out, and you have an obligation if you want to, receive the PIP benefits under your policy to do that within the first 14 days. So very, very important thing for you to remember after you're injured in a car accident. Don't delay. You should seek treatment right away. Next question I have for you, true or false? Since I just kind of brought it up with the PIP, Florida's no-fault insurance means you can't ever sue the other driver. Is that what no fault means in our state?
That's an absolute falsehood.
Right.
You certainly can sue the other driver. The other driver does have protection from certain type of non-economic damages unless you can prove that you crossed a certain threshold. The most typical one being a doctor saying that you had a permanent injury within a reasonable degree of medical probability. But even if you don't have a permanent injury, you are still entitled to, make a claim for your economic damages. So that is another falsehood.
Actually, absolutely agree with that. I just think the state in general, people have a misconception, or I feel like it's a misnomer as far as what no fault means. And so, of course, again, I encourage you, when you have questions about that, you're not sure, can I make a claim against this person? I thought Florida was a no-fault state. We have a lot of tourists in our state, especially during the summertime. They think, oh, I'm in Florida now. It's the no-fault state. I don't think I can make any claims. Don't assume that, okay? Absolutely reach out and ask your questions to experienced personal injury attorneys at Perenich, Caulfield, Avril Noyes, that we can obviously explain that law to you a bit better, because I do think people get confused about that, especially people that come from states that don't have the no-fault statutes. Next question, true or false? You can post pictures of your car accidents and injuries on social media with no legal consequences. How do you feel about that one?
Well, I have to say that's one that has two answers. That could be true, or that could be false, depending on the picture.
Yep, depending on what you posted.
But, people really have to be aware that social media is something that is used by 100% of insurance companies against you. And essentially what they would look for is any type of photograph that shows you enjoying yourself.
Oh, yeah.
That shows any degree of physical activity, because then they want to make a claim that your claim for injuries is inconsistent with that. Right. Oh, look, there's a picture of the person hiking in North Carolina. Oh, look, there's a person, standing at the park, holding their child's hand. Like they couldn't go to the park if they were really injured. So, the bottom line is they will always use those against you if they can. And frankly, I find a lot of times that what's actually shown is really something that's quite normal. It's just, but then they take the position, oh, look, they can do normal things, therefore the person is normal. So unfortunately, it can be misused against you. And, the thing that you don't want to have is kind of any out of character shots where you're doing something that you don't normally do.
Right.
But, certainly it's a new age.
Oh, for sure. Everyone wants to document every moment of every day. Just getting up and getting dressed, you'll see videos now. It's like, get ready with me as I do this and that. And it's like, oh my gosh, to me, it's a bit of oversharing that can be taken and misconstrued by any insurance company or defense lawyer.
Yeah, 100%.
I remember a case that you and I actually tried together, and I don't think we'll ever know how much the jury, put weight on. But I remember the defense lawyer very much harping on a photo of our client playing golf or something like that. And it's like he used it repetitively throughout the case. And, I think that's a smart tactic from the defense when it comes to trying to use something that's, common task. No one, necessarily in that case, I don't think he said he couldn't do anything, or that, he was, unable to try certain things or activities or sports, but they'll use it and say, well, you shouldn't be able to do this type of action or this type of movement if you're making the claims that you're making.
Right.
So.
Yeah. If you are really hurt, then you shouldn't be able to shoot a gun.
Yep.
So there should be no pictures of you at a range, even if the person never said that they stopped shooting their
exactly
gun. But that's the way it is. I mean, it's that's how that can be used against you, even if it's something that is not inconsistent with what you've told the other lawyer and what you've told your doctors.
And I think one thing for people to be aware of, there was a time that I think judges were limited a lot of what you can get. Some certain things are private, and if your account is private, you shouldn't be entitled to a lot of these things. But I think now the case law does allow for some latitude when it comes to the pictures you post on your page, and you should assume that what you're posting is discoverable. So.
Yeah, I agree. I mean, we see it more and more with the advent of social media, and so it can be used. Of more concern is I think it can sometimes be misused by the defense, but nonetheless, you have to be cognizant of it, because if you're putting stuff out there, then you're doing so at the risk of it being misconstrued.
Exactly right. Exactly right. So my next question, I think, can be answered a little bit differently now that the law has recently changed in the past 2 years. But I want to, of course, ask, true or false, if you are partially at fault for the accident, we're talking car accident, you are completely barred from recovering damages in the state of Florida.
That could be true, depending on how big that partial is, because Florida, of course, is what was once known as, and still is, a comparative negligence state.
Right.
Where whenever you make a negligence claim against somebody else in a car accident scenario, more than likely they're going to be making a claim against you saying, hey, even if I was negligent, you were comparatively negligent. And then they ask the jury to compare the fault and utilize a 100% pie of fault, so to speak.
Mm-hmm.
And then the jury has to dole out that pie. What percentage of fault is attributable to the defendant, and what percentage of fault, if any, is attributable to the plaintiff? Well, the bad news is if you get the question answered against you as the plaintiff and you're more than 50% at fault, you're out of luck in a negligence case because of some new laws that we've had.
Right. And despite the fact that there was obviously, could be 40, 48, 49% on the defense, their portion of that, no matter how large it is no longer recoverable.
Yeah, I mean, basically, that's a law that protects negligent defendants. You could be found to be negligent by a jury and still owe nothing now in the state of Florida.
Yep.
Shocking change of the law, but
I agree.
That's, that happens without people even understanding it.
Absolutely. And this next one I'm going to ask because I feel people are still very misinformed about this. And I don't know that it's going to change. I know it's gone up to the legislature many times, but the last time it was vetoed by the governor. True or false, Florida drivers are not required to carry bodily injury liability coverage.
That, unfortunately, is true. And it's probably one of the most misunderstood things that I see and hear in my practice.
Mm-hmm.
When we get the insurance information, and I was just signing a letter tonight, that the other party does not have any bodily injury liability coverage, our clients are startled and say, well, what do you mean? I thought in Florida you had to have auto insurance coverage. It's a mandatory auto insurance coverage state, they'll tell me. I'm like, well, yes and no, it is, but it's not mandatory that they have the coverage you need. The only thing mandatory is folks have to have $10,000 in property damage coverage, and they don't have to have any bodily injury liability coverage to pay for injuries to you.
Exactly.
And that is a tremendous shock to people. They don't understand. And that leads me right to my next point, which is that's why you have to have uninsured motorist coverage here in the state of Florida. If you're driving around without uninsured motorist coverage, sometimes referred to as UM, then you're making the biggest insurance mistake ever. Because I can tell you, if you ever have to come into our office after you or a loved one's been involved in a very serious accident, and we're talking, we see it all. We see
absolutely
very serious accidents, amputations, death, and the other person that caused the accident has no bodily injury liability coverage. And, here you are, you've incurred hundreds of thousands of dollars in bills at one of the local trauma centers. And the question people ask of me is, well, how am I going to pay that?
Mm-hmm.
And I have to look at their own coverage. Do you have health insurance coverage to pay these bills? Do you have auto insurance coverage?
Right.
And the auto insurance coverage that we're particularly looking for, in addition to PIP that pays a pittance of your medical bills, 10 grand.
Right.
We'll look for a coverage called medical payments that will typically pay another 5,000 or so. But then, unless you have you're out of luck, because chances are the person that caused your accident that has no bodily injury liability coverage has no bodily injury liability coverage for a reason. They don't have any money.
Right.
And so, the law does not equalize things the way it should. People think the law is a great equalizer. Sometimes the law can't equalize. When someone causes you horrific damages, millions of dollars worth of damages, doesn't necessarily mean that they have to pay you millions of dollars.
Right.
You might get an order that says they have to, but if they don't have the money, how are they going to pay?
How can you collect?
So if they have no assets or insurance. So that's probably the most frustrating thing that I see in my practice over the years.
Absolutely.
Is people buying a lot of bodily injury liability coverage to protect other people that they may run into.
Mm-hmm.
And the unlikely event, they're negligent. But then they reject uninsured motorist coverage for themselves, for their family members, and for everybody in that car. You have no protection against the uninsured motorists that are out there and that have no bodily injury liability coverage. And, at one point in the state of Florida, the estimates in South Florida were as many as 60% of the drivers had the dead minimum. They didn't have any bodily injury liability coverage. So you get an accident with those people, you have all these medical bills,
right?
And they're coming over to you. You're going to have to pay them.
Right. I agree. We sign those letters advising clients of this more often than I'd like to see happen. Yeah.
We must decline to represent you further.
Yep. Yeah. And so that actually brings me to my next true or false, because you'll get that follow-up question, which is, well, if the driver doesn't have any other insurance, can't we just sue them? True or false?
Can't we sue them personally? And the answer is yes, you can. That's true. You can sue them personally.
Mm-hmm.
The problem is that doesn't necessarily do anything for you. Yeah. At the end of that lawsuit, you might get a judgment from a court that says that person owes you $1 million.
Right.
The problem, however, is if the person doesn't have $1 million, you're going to have a very difficult time turning that piece of paper that says they owe you the money into actual dollars. You have to try to execute on the judgment, and then certain things are protected, like somebody's homestead.
Right.
And more important, if they just don't have the money in the first place or the assets, that piece of paper is not going to do you any good. And they can also, in most circumstances, run to a bankruptcy court.
Sure.
And just bankrupt out from underneath that judgment. And that judgment doesn't come free.
Yep.
In other words, your doctors would have to come to the courthouse to testify in favor of you. And each one of them's
with a hefty cost,
$5 to $10 grand a piece.
For sure. Mm-hmm.
So that's why, it's just the take home message is uninsured motorist coverage. If you don't have it, you're making the biggest insurance mistake. And don't assume that you have it. I've had plenty of clients. Oh, I know I've got that. I've got full coverage. Or,
no.
Oh, I know I got that. I have a newer car and I was required to take out really good insurance.
No.
And none of those things are true.
Right.
Uninsured motorist coverage is a voluntary purchase by you. And they don't even want to sell it to you.
Yeah.
So they have to offer it to you if you buy bodily injury liability coverage to protect other people you might be negligent and run into. But then it has to be offered to you. But it's offered to you in a way where they'll encourage you to reject it. Say, oh, you can just reject that coverage. You don't need that. You get health insurance. You don't need it.
Right.
So it just, uninsured motorist coverage is where it's at.
Right. And as we close out our little segment here about car accidents, that is the takeaway. I think if you've been a faithful listener at all, then you know that is something that we always encourage you to do. If you'd like us to take a look at the policy just to make sure you've got it right, you understand that you have the coverage, but you're not sure and you think you do, give us a call. We're definitely always happy to take a look at your deck sheet or your policy just to confirm whether or not you actually have the coverage that we're talking about, which is the uninsured motorist coverage. So I think this is a good time to take a short commercial break. And then we'll shift gears after the commercial to start talking a little bit about premise liability, which is also known as slip and fall kinds of cases. We'll get a little bit of true and false responses from Bryan Caulfield right after this commercial break.
This is the Tan Talk Radio Network.
After a car accident, there are many questions that you need answers to. Who pays for my car repairs? Who pays for the medical bills? What about my lost wages? And more. The personal injury law firm of Perenich, Caulfield, Avril Noyes has been answering these questions for their clients for nearly 70 years. Since 1955, they've been a voice of the injured in the legal system. As one of the longest established law firms in Tampa Bay, Perenich, Caulfield, Avril Noyes is here to answer your questions. Listen to their live call-in radio show on this channel every Tuesday evening from 5 to 6 p.m. or call them at 727-796-8282 or visit them at voiceoftheinjured.com. Offices Clearwater, non-attorney spokesperson.
This is the Tan Talk Radio Network.
And we are back. This is FLALAW live on the radio. Thank you for tuning in once again. This is your live legal call-in talk show, and we are here every Tuesday at 5 o'clock. Hopefully you've been tuned in since the beginning, but if not, welcome. Feel free to share the show with your family members and friends. Let them know that we are live on WTAN, AM 1340 and FM 106.1. We're also streaming live right now on Facebook and YouTube. Let everyone know in case they have some personal injury or legal questions that they'd like to be answered live on the air. I am here, myself, Jacqlyn Bryant, as a personal injury attorney at Perenich, Caulfield, Avril Noyes, along with my law partner, Bryan Caulfield, and we are answering some questions here live on the air. And I have Bryan going down the list of some true and false questions, topics and related to personal injury. So if you missed the auto accident related segment, definitely go back and watch the show later. It is and will be posted on most podcast platforms, that is Spotify, iHeartRadio, and Apple Podcasts. That way, if you missed it, you can certainly buff up on that later and get some knowledge in terms of Florida car accident law. With that being said, let's shift gears a bit here to Florida premise liability law. Again, that's commonly trip and fall, slip and fall type cases. And again, this is another area, Bryan, that I think people get quite confused on, and we often have to explain when it comes to liability and the way these claims are presented through the legal system. So the number one question I think people still have a lot of difficulty understanding, true or false, if you slip in a store, let's say grocery store, the store is automatically responsible. True or false?
Big time false and
Right.
Big time misunderstood, because I can't tell you over the years how many times I've come in to a new client meeting and they're anxious to tell me that they fell on so-and-so's premises and therefore the landowner is liable because that's the way they say it was in New York, or that's the way they say it was in some other state that they used to live in. And I have to give them a lesson on Florida law. That's not the way it works down here.
Right.
As you know, premises liability cases are among the most difficult cases that we work on. And that's because the very person who suffers the injury that has the burden on them to prove the elements of the case is usually in the worst position to ever gather the information necessary to prove their own case.
Right.
And by that, I mean, you've got to prove that the defendant had actual knowledge of the dangerous condition. That is, they knew it was there. That's one way you can get liability, or that they created it. That's rare. It's very rare. I have had cases where a manager's run up and said, I told them about that spill and I told them about that.
Right.
So yeah, every once in a while, 1 out of 100 cases, you might get that. But more often than not, it's a client that comes in and says, I slipped on a foreign substance on the floor. I think it was water. I'm not sure. And my question is, who put it there? I don't know.
Yeah.
Next question. Well, how long was it there?
Right.
I don't know that either. They took me away on a gurney. And so those cases are very difficult. You've got to prove actual or constructive knowledge. And by constructive knowledge, meaning that the dangerous condition was in existence for a long enough period of time so that they should have known about it.
Right.
And that makes for a very high burden when someone's injured. The last thing you can probably do is say, all right, everyone, please stop if you're within earshot of this. And if you've come down aisle 6 before, 10 minutes ago, can you come over and tell me whether this spill that I just fell on was here?
Right.
Of course, there is, to me, one of the biggest developments in legal related things. We talked about social media, but one of the other biggest developments is the use of cameras.
Yeah.
Because sometimes the only way I've been able to prove my case is through the use of cameras, where you get the camera that shows that this particular thing was created, say 10, 15 minutes, 20 minutes beforehand by either a store employee or even another patron. And you get there. Therefore, you have a jury question as to whether or not the 20 minutes that it was there on the floor was enough time for the store ownership to see and clean that up. But that is a very misunderstood area of the law because just like you said, everybody believes that, well, the standard, the threshold, the burden that I have is simply to prove that I fell in their store.
Right.
And then the burden switches to them to prove why they weren't negligent. No, it's just the opposite.
Right.
And in fact, many slip and fall cases will never see the inside of a courtroom because if you don't come forth with sufficient evidence to make it a jury question, the judge throws the case out without you ever, seeing a jury. And I have some clients say, well, they'll feel sorry for my mom. She broke her hip and it's her. Well, she's never going to get
if you
to
ever
a jury.
get there, right? Yeah.
So
that's absolutely right. And you made a good point about the cameras. Sometimes that is the evidence that we're looking for, and it's in the hands of the people that we're suing.
Yes.
And
always worrisome.
Yeah. And I don't know if you ever encounter, you'll get this video and it's all different angles from different parts of the store. And it's never the angle that
shows every single place in the store except for the place your client fell. Yes. I have had that experience.
Yes, conveniently. And so one thing I do recommend, as Bryan mentioned, after someone just fallen, they don't necessarily think of stopping and asking for witnesses and gathering names and maybe not even taking pictures, although nowadays you have your phones right there and the ability to do so. But that's something that I would recommend, if there's someone there, if you can't do it, if there's someone around that has a phone, get those photos so that you can understand and appreciate the quality of what it was, the condition and what it looked like. Because as Bryan mentioned, you can't always prove actual notice, but sometimes constructive notice can be, pieced together by circumstantial evidence. And the way that item, let's use a banana peel, the way that item looked or that object or that foreign substance looked can then present, evidence of constructive notice, depending on, if it's brown and it's rotten and it's been smushed through, or there's tracks and there's smears, that kind of thing could potentially keep the case alive, as opposed to, like you said, getting thrown out on summary judgment. So again, those are things to kind of think of. Obviously no one expects to have a trip and fall or slip and fall type of injury, but just you falling alone on that property is not enough, as we now know. So true or false, if there is a wet floor sign present and you slip and fall in that area, you cannot sue.
I'm going to say false on this one.
Okay.
Because, the bottom,
do tell.
the bottom line is it doesn't make it an easy case for sure. But, really, the law really requires the landowner to do two things. It requires them to warn of the dangerous condition, but it also requires them to correct the dangerous condition. So I don't think as a store you're going to escape liability when you got a leak that you've known about for weeks and weeks and weeks on your refrigerator. So you just throw a wet sign up somewhere in that area and you think that insulates you from liability. I don't think that's going to be the case. No,
I agree with you. I think elements, may no longer be there in terms of the duty to warn, but sometimes, water puddles can, extend out much further than, the area where that sign could exist. And there's so many different factors.
Right.
But like you said, they're very tough case, and that's something that I would imagine the defense would be all, over, that photo and showing that there was a sign and that sort of thing. But, all is not lost. I think it is something that potentially could be worth pursuing, depending on the circumstances and the facts of that particular case.
The problem is, in a case like that, you'd likely have a very high finding of comparative negligence against you.
Yeah.
And so if it's more than 50%, you get nothing.
Nowadays, you get nothing. And so a case like that, pre-tort reform bill in 2023, maybe you have a better shot at a recovery than you do now. And that kind of a case is going to be very challenging these days. Okay. So then I think we talked about this a little bit off the air or in the beginning. True or false, property owners are responsible for injuries from wild animals on their land. So you did touch on that a little bit.
Yeah, I mean, that can be answered true or false.
Right.
And generally, it's false.
Yeah.
But, you could conceive of a situation, because I've conceived of one,
The theory.
where, it's one thing to say, well, wait a minute, it's a wild animal that injured you on my property. But then the question is, why was the wild animal there?
Yeah.
Perhaps you could think of a situation where, somebody over a period of time is not disposing. If you're in grizzly country,
Yeah.
and you have a campground owner that's
Attracting all the bears.
Yeah, that's not properly, getting rid of the garbage, and it's attracting a bear, and it ends up attacking somebody. There wouldn't be an easy case. It's one of those kind of law school questions. Certainly,
it does sound like an exam question. Yeah,
it's pretty rare, but I still think under certain situations, you could be liable as a landowner for not properly protecting the invitee against the danger posed by a known wild animal or wild animal problem.
Right. So there's several pieces that would have to kind of perfectly align for something like that. So, so that was a tricky question. It doesn't necessarily fit nicely into a true or false there. But similarly, we're talking about kind of conditions that aren't necessarily natural to the property. In Florida, can the weather, something like rain, sometimes excuse the property owner from responsibility?
Well, that depends. That's the kind of typical question where we see entering grocery stores and things like that, where they put out, let's just say, one mat.
Yeah.
And the mat gets totally soaked through with water, and the mat doesn't get changed out. And, the door on the bottom is not cut appropriately. So water is literally flowing in. And so then you could be in a situation where the landowner is responsible for something, natural rain.
Sure.
So,
I just had a very good result on a case just like that. It had rained, and the person was coming back from her lunch break in this building that had multiple tenants in it. They had a person that worked on the property to keep it clean, and it was I think it was like a day porter of some kind. And he was responsible for doing just that, checking the mats, making sure the floor is not wet around the door. They even had a rainy day policy to kind of be constantly mopping and checking those kinds of things. And sure enough, this gentleman said, well, I've got 2 buildings that I'm responsible for, and I'm the only day porter for both these buildings. And I don't think I had even gotten to that side of the office or that building yet. And so it's just too much for me to do in one day, kind of a thing. And so, sure enough, he kind of fell on the sword and said, I just don't think I had gotten there in time before the incident occurred. So, and it ended up being a good outcome for my client. So in those situations, I do think that it just depends on the facts and the scenario. But in your mind, Bryan, are there times where those kinds of things, water, rain, or wind, and different obstacles that are that would preclude any type of case that could be made against the property owner?
Well, yeah, and the answer is they don't preclude it. I mean, like, for example, if we were in a northern state, we'd be talking about ice, which occurs every winter. But, property owners up there can be liable for not getting the ice off their sidewalk.
Salting them.
Not taking appropriate, steps to try to ensure that accidents aren't happening on their property. So it all gets down to a question of reasonableness. You have the obligation to maintain your premises in a reasonably safe condition.
Right. I absolutely agree 100%. And so again, if there's questions about that and you have a trip and fall case and you're not really sure, you should be definitely giving us a call so that we can help, review the case with you and let you know what your rights and options might be and whether you have a viable claim. Shifting gears, as we wind down on the show, I definitely want to make sure we spend some time talking about medical malpractice because once again, this is an area that I think we see a lot of confusion in terms of the kinds of cases that come in. I'm sure, Bryan, you unfortunately have to reject more than you accept when it comes to these kinds of cases, simply because people just don't understand what claims are considered malpractice. With that being said, true or false, a bad medical outcome always means some sort of malpractice occurred.
That would be false.
Ding, ding, ding.
Oh, I think I got that one right. That would be false. As a matter of fact, there's actually a statute in Florida that basically says just the opposite. It said that just because there's a bad outcome doesn't mean that there's malpractice.
Right.
And many times, if you ever try a case, they'll be asking for a special instruction on that regard. So no, bad outcomes by themselves are not enough to make a claim for medical malpractice.
Okay. Well, then true or false, do you have to prove another doctor would have acted differently to win a malpractice case?
Well, yeah, because you have to prove that the doctor that you're making a claim against, that he fell below the standard of care. That is, that every other doctor that would have done this reasonably would have taken a different action than this doctor did, that he didn't practice in conformance with the standard of care and therefore fell below the standard of care, and that therefore he wasn't a reasonably careful physician. So they are the most difficult types of cases that you will ever handle. They are the most expensive types of cases, and it is an area of law where, in my opinion, the law is written to protect the negligent doctors. You would think that laws would be written to protect the patient, but you might be shocked to learn that all the doctor has to do is offer to admit that they made a mistake, and they can cap the non-economic damages they owe at a very, very low amount. And so, people, when they finally come into our office, no one views themselves as a potential future medical malpractice victim.
Right.
So they don't have a lot of interest in what's going on with the legislature. They just figure that when their time, if it ever comes to make a claim, the law will be as they think it is.
Yep.
And they're shocked to learn what the laws actually are in the state of Florida and how some of those laws are incredibly difficult and actually protect the negligent wrongdoer.
Absolutely. And I think my next question is one of those barriers, I think, a lot of times that you don't see in other personal injury cases. True or false, in Florida, you need an expert witness to bring a medical malpractice case.
You absolutely do.
Yeah.
Yeah. I mean, that's the one kind of case that, you're going to be required to have an expert opinion to even bring the case.
To even get your foot in the door.
You can't even bring the lawsuit without already having an expert on board that's given you a written affidavit saying the records were reviewed, a good faith investigation was done, and there are reasonable grounds to believe that there's malpractice. And then when you go to an actual trial, you better not rest your case without having had a doctor come in and say, a similar healthcare provider, they're called. They have to be practicing the same type of medicine as the doctor you're suing.
Right.
And then you're going to have an opinion from that doctor that the defendant doctor fell below the standard of care. If you don't have that, you'll never get to a jury. But the most amazing thing about that, in my judgment, is some of the cases that are the biggest and the clearest acts of malpractice. I've been involved in cases where there is a little known statute that allows the doctor to just offer to admit liability and demand arbitration. And that caps the non-economic damages to $250,000. And that's no matter how many defendants were involved. And so, and I had a situation where, someone was killed as a result of the malpractice, but the defense makes a business decision. We'll just offer to admit liability.
Yeah.
And that way we'll cap the damages at $250,000 for non-economic damages. And for the particular victim that I had in that case, all the damages were going to be non-economic, mental pain and suffering caused by the wife's death. Because the wife had already retired. She didn't have economic damages like lost wages.
Yeah.
But certainly they'd worked a whole life, planned a whole life to, have a wonderful retirement. And the beginning of their retirement turned into the end of her life. And, the way that law that sits out there, nobody knows about it.
Mm-hmm.
And it really can work a very grave injustice, in my opinion.
Yeah. Now, you made a good point about this example you just raised about someone who was killed. I want to touch on that before we close out, because there's obviously has been in the news lately. It recently went up to the legislature. And this next question, I think, is relevant. So, true or false, only a spouse or child can bring a wrongful death lawsuit in the state of Florida?
Yeah, that's not true.
Mm-hmm.
It's not just a spouse or child. It's the personal representative of the estate is who brings a wrongful death case, for example. But who can recover, who is actually a survivor under the wrongful death law, determines whether you even have a case.
Exactly.
Because, like you talked about, if you're someone that's not married and has no children, then, chances are there's may not be anyone to complain of your wrongful death. I mean, it really just depends who the victim is, and whether they had a spouse, whether they had minor children, and that can be the determining factor in whether or not the case can be brought.
Right. And so in that medical malpractice setting, when someone is killed as a result of medical malpractice and there is no spouse or there is no minor child, is that something that we have now known to be called a kind of a free kill, right?
Yeah, you're out of luck in that situation. And we tried to get the law changed on that, but it seems as though it's going to be unsuccessful because the governor indicated he would veto such a bill.
Well, Ryan, we are winding down the show, and I just want people to obviously have an opportunity to know if there is something that we talked about that has sparked your interest, or a case that you have that you would love to talk to us about. Do not call the radio station. Call us at our law offices at 727-796-8282. Bryan, it's been a pleasure as always. Thank you for
Jacqlyn,
joining me.
having me.
Please tune in, as always, every Tuesday at 5 o'clock with FLALAW live on the radio. Next week, you should hear from my partner, Matthew Noyes. He'll be on the show. And again, tune in onto our podcasts that are on Spotify, iHeartRadio, and Apple Podcasts. Until next week, we'll see you Tuesday at 5 o'clock, FLALAW live on the radio. Good night.
WTAN Clearwater
FM 106.1.